Good morning. Welcome to the workshop on employment rights and disability insurance. My name is Jill Randall. I work with patients and families through Be the Match, and I'll be your moderator today. This session is being audio recorded for the benefit of those who can't attend the meeting. So when you ask your question, please raise your hand and we'll bring a microphone around you. We'd like to get all the questions recorded as well for those who will be listening later to the workshop. Please join me in welcoming Ms. Deborah Wolf. Ms. Wolf is a supervising attorney for Legal Health, a division of the New York Legal Assistance Group, where she works primarily with clients who have cancer. Ms. Wolf specializes in disability law and has counseled and represented clients in various legal matters, including disability leave, insurance disputes, estate planning, and employment concerns. Welcome, Ms. Wolf.
Thank you. Good morning. So, as mentioned, I'm an attorney, and I work in New York City. And I provide free legal services for people with cancer. And a lot of time is spent talking with clients who are trying to work through their treatment, might have to take a brief medical leave or an extended medical leave, and counseling them on what their rights are in the workplace, what their employer's responsibilities are, and the laws that protect them. So we'll have an overview of that today, and there will be plenty of time for questions. So we'll be talking today generally about workplace rights and the laws that protect you in the workplace. A lot of people call me and ask about disclosure. Do I have to tell my supervisor, my office, that I've been diagnosed? We'll talk about that. Reasonable accommodations, the Family Medical Leave Act, and then disability options for people that might have to take either a temporary or a more permanent break from work to focus on their health. So these are generally the laws that protect people. Most states are what they call at-will states, meaning that an employer can hire or fire an employee at will unless there's an employment contract. And generally for any reason, it could be because they don't like their personality, they don't mesh, they don't like their work ethics, but they can't take any adverse action because they learn that their employee has a disability or has been diagnosed with an illness. And the laws that protect employees, the two main laws we're going to talk about are the Americans with Disabilities Act, Family Medical Leave Act, but then I also urge everybody to also understand what your state laws might offer, and we'll talk about that a little bit as well. So let's start first with the Americans with Disabilities Act, or as very commonly called the ADA. This is a federal law, so it applies equally to all 50 states. And it applies to employers with 15 or more employees. So to be covered under this law, you have to work in an office with 15 or more employees. And it prohibits discrimination based on disability. And it also provides that your employer must provide reasonable accommodations. And we'll talk about that in a minute in terms of what are reasonable in terms of accommodations and how to request accommodations. So under the ADA, a person is considered disabled and covered under the law if they have a physical or mental impairment that limits a major life activity. And a major life activity could be anything from walking, seeing, working, sleeping, breathing, long list of major life activities. And the ADA doesn't list specific diseases or conditions, but recently the law was amended. And it's now the ADAAA, or Americans with Disabilities Act Amendment Act. And the ADAAA was designed to curb a lot of problems that came up with the ADA and determining who was covered under the law. So with the newer law, there's a very liberal determination of who's covered under this law. It makes it much easier for a person to establish that they have a disability within the meaning of the ADA. And some of the changes include that it specifically covers impairments that are episodic or in remission. So a lot of cancer patients whose cancer is in remission would still be covered under the new law. Under the old law, probably not. And also with regard to mitigating measures such as medication or hearing aids, with the old law, let's say, use the example of blood pressure. Somebody has serious high blood pressure. With the old law, if medication controlled the high blood pressure, they weren't considered disabled. Under the new law, the fact that somebody's taking medication doesn't affect their coverage under the law. So definitely some good changes with the new law. One of the things I mentioned before is that it's also important to know your city and state laws, and I know people here are from many different states in the country. New York, as an example, has very strong city and state human rights laws that cover employers with 4 or more employees. So it offers the same protection as the ADA, but to a larger group of people. I know New Jersey also has a very strong state human rights law. So it's important to know what your state law is, because it might offer more protection actually than the ADA. So these are common questions. We'll talk first about disclosure. That I talk to many people every day. These are common questions that come up. Does an employer have a right to ask any medical information about me during a job interview? Is there any time that I have to tell my employer that I've been diagnosed with cancer or any illness? Is my confidentiality protected if I do tell? And then, of course, can I be fired if I disclose, if my boss finds out that I've been diagnosed with cancer? So under the ADA, they actually separate their disclosure rules into 3 distinct areas. The first one is pre-employment inquiry. So when somebody's going to apply for a job, generally no disability-related questions are allowed. An employer can ask about somebody's ability to perform a job function. I guess an example of this would be, let's say somebody goes in for a job interview and they're limping. Their employer, prospective employer, is not allowed to say, "What's wrong? Why are you limping?" That would be in violation of the rules of the ADA. What the employer can ask is, one of the essential functions of this job is carrying 30 pounds up a flight of stairs. Are you able to do that? That inquiry is allowed. But generally, no specific medical questions are allowed while somebody is interviewing for a job. But employers can also ask somebody to demonstrate how they might be able to perform a job, but that's really the extent during the pre-employment inquiry. Once somebody has gone through the interview phase, oftentimes employers will offer conditional job offers. Not all the time. Sometimes a job offer is made and everything is worked out, but there are times when employers will condition the job offer on certain qualifications or qualifying events, and one of those might be medical exams. During the conditional job offer, it's really an open field, and the employer can ask just about anything that they want medically. They can send their employee or prospective employee for a medical evaluation, but they can't single out people and say, well, I'm going to send them for a medical exam because maybe they don't look right to me, or they look like they might have an issue. They have to have a rule where everybody coming into that job position or that job level is subject to the same medical inquiry. This is tough because it sometimes forces people to disclose that their health conditions where there really is no reason for them to do it, but under the ADA they're required to do it. And in fact, people are more protected when they disclose. I have people that call me all the time and say, I don't want to tell them I've been diagnosed with cancer. There's no reason to. But the truth of the matter is, if they don't disclose during this phase and the employer determines that they do have a medical condition they should have reported, the employer does have the right then to renege on the job offer, not because the person has a disability, but because they didn't disclose and they misrepresented. So during this phase, it's people are more protected when they do disclose. If somebody does disclose, they are protected, and the employer can't reject based on their health unless the employer could demonstrate that they wouldn't be able to do the essential functions of their job, or they pose a direct threat to either themselves or somebody in the workplace, and that doesn't come up that often. So then the third are on-the-job inquiries. You're working, you've got the job. What is it that my employer is allowed to ask me in terms of my health? Any inquiries must be job-related. They must be consistent with business necessity. Certain jobs have a higher level of inquiry. Jobs that have public safety components, such as a firefighter. I worked with somebody once who worked in a nuclear power plant. I think the employer there has a higher right to make job-related inquiries on health because of the public safety aspect. Usually, if you're working in a business or for a company, there's not a lot of business necessity in terms of making inquiries about somebody's health. So if the employer has a reasonable belief based on objective evidence that an employee's ability to perform their essential job functions will be impaired or will pose a direct threat. So in terms of direct threat, again, using the example of the person that I helped that worked in the nuclear power plant, they were having periods of dizziness and fatigue on the job. And in that case, I think the employer had the right to say, this could be a direct threat to many people in the vicinity if you don't do your job correctly, because he did work for a power plant. But those I think that's a rare circumstance. And just to mention, it doesn't apply to an employer's drug policy. Drug policies are outside the scope of the ADA, and employers can have reasonable drug policies, and they're not really governed by these laws. So reasonable accommodations. I do a lot of work with clients who need to request reasonable accommodations. So under this law, the ADA, and also under many state laws, you have the right to go to your employer and say, I can do my job, I can do the essential functions of my job, but I need an accommodation. Under the ADA, there's no set list of accommodations. It's basically something that you think will help you do your job better, help you manage your job. Some of the common accommodations that I have worked with clients to set up include alterations in their work schedule, perhaps a shorter workday. I work with a lot of people who take medications in the morning and just can't be to work by 9 o'clock in the morning. An accommodation might be that they have a later start in the morning. I've worked with certain people who have set up an accommodation for working from home. Recently, I worked with both a writer and a graphic artist. The important thing to remember is you have to be able to do the essential functions of your job with the accommodation. So for some positions, working from home is an option. For others, simple example of a store clerk would not be able to do the essential functions of their job from home, so that wouldn't be a reasonable accommodation. Even requesting a part-time schedule, it really is, and reassignment. I've had people who have said, I can't do my job, but there's another job open that I feel that I could do. And changing job positions, changing job locations to an office perhaps closer to home to cut down on travel time also can be reasonable accommodations. The one thing about job transfers is that there was a case, a Supreme Court case actually, that said, although job transfers can be reasonable accommodations, when you're transferring, you don't get priority. So if there's a list of people waiting for this job, your name gets put at the bottom of the list. You don't move up to the top of the list because, you're covered under the ADA. So sometimes with a job transfer, it doesn't happen immediately and might not be the best accommodation. But when people call me, I always say you really need to think about what your employer can do to help you do your job. And it can be something as simple as an ergonomically correct chair or alterations to your computer. It really is on a case-by-case basis. Your employer can't say no. It has to be what's known as an interactive process. So they could say, I'm not sure this accommodation is going to work for us. Let's talk about what's going to work for both you and for the company. But they're not supposed to come back and say, no, we're not going to do this for you. The only time that it can be rejected is if it causes an undue hardship for the employer, and that's a really difficult burden for the employer to meet. Even financial hardship is not an undue hardship, but then it's on a case-by-case basis. You know, if we're talking about a large company like a large bank as opposed to a smaller employer, the burden might be more on the smaller employer. So it really is, looking at it case by case. When requesting reasonable accommodations, I always suggest if there is a human resources, go to HR. I have a lot of people that go to their supervisors or their managers and say, I need an accommodation, this is what I need. And the manager always says, oh, we don't do that here. They don't know. They don't understand what the laws are. They don't understand their responsibilities under the laws. That's what HR is for. So if your company has a human resources, that's where you need to go. I always suggest that it be done in writing and include a letter from a doctor that says, I'm the treating doctor for Jane Doe. Here's what her medical condition is. And the doctor can either list specifically what the accommodations are, or if the doctor prefers, they can say, I've reviewed the list of accommodation requests and they're medically necessary. But important for the doctor to say that Jane's able to do the essential functions of her job, because that's what triggers coverage under the ADA. An employer is not allowed to request medical records. The doctor's letter is sufficient. Some employers might have an accommodation form, most do not, and usually it's triggered by a letter from the employee. Sometimes it's done verbally. I've had clients who have sat down with HR and talked about it, but I always try and get them to get something in writing to confirm that the accommodation is in place. And I think we talked about the interactive process. So I mentioned the physician's letter. Again, I always stress that the doctors say that the employee can do the essential functions of their job and that the accommodation is medically necessary, and that protects the employee. A lot of people ask me about confidentiality. When you make a request for an accommodation under the ADA, it's not supposed to go into the employee file. It's supposed to go into a separate medical file. So if your supervisor wants to look at past performance reviews and decides to look in your employee file, there should be no medical information contained in that file, and that separate medical file is available only to people with a need-to-know basis. So that's going to be either HR, people higher up, and not necessarily a direct supervisor. And I put down the website, JAN, the Job Accommodation Network. For people that are thinking of accommodations, it's a terrific website. It's illness-specific. It talks about common accommodations for certain diagnoses. It talks about how to request an accommodation, and has a lot of really good information about reasonable accommodations. The EEOC is the government organization that enforces the ADA, and they also have a lot of good information about your rights in the workplace. If you look at the EEOC website, they have a lot of short flyers as well as longer directives on what a person's rights are under the ADA. But Jan is terrific. So despite these laws, discrimination does occur. I will say in my practice working with employees that employers usually are willing to work and setting up accommodations, but discrimination does occur. I always tell people, think about disclosure, who you're going to disclose to. You're protected if you disclose, as I said, to HR. You're not necessarily protected if you tell your friend in the workplace, look, we've been working together, I like you, I'm going to tell you something about me, and that person tells everybody else in the workplace. There's generally no legal protection. So be careful about who you talk to. Keep records. And the first step is always to talk to human resources, because sometimes they will be very interactive and they will help curb any discrimination that's occurring. And then you can file complaints with various organizations, but I always suggest talk to an attorney because they will be able to advise as to whether or not there is discrimination under the law, and more important, deadlines, because all of these laws have very strict deadlines that you have to comply with. I want to talk a little bit about FMLA. FMLA is a law, again a federal law, protects the job of an employee who needs to take time off from work. It applies to employers with 50 or more employees, and you have to have worked at your job for at least a year, and if so, you're covered under FMLA, and you're entitled to 12 weeks of job-protected leave. You can take that in a consecutive time and take 12 weeks off, or you're entitled to something called intermittent leave. So somebody who might have treatment every other Thursday can take intermittent FMLA leave every other Thursday and perhaps every other Friday for up to 12 weeks of protected leave. I have clients who have used it to take off one day a week, and it actually only almost covers them through the entire year to shorten their work week. When you calculate how many days would be covered under 12 weeks. I'm not going to do the math right now, but how many days would be covered. And insurance benefits must continue during the FMLA period. So if you have employer-provided health insurance, that has to continue while you're out on leave. If you pay premiums, you have to continue paying your share, but your benefits continue. Under the ADA, you have the responsibility to go forward and ask for an accommodation. Under FMLA, your employer has the responsibility to advise you if you're taking medical leave that you have the right to this job-protected leave. So FMLA, most employers have a form. It requires a part completed by your doctor to affirm that you have a serious health condition. You can also take FMLA leave to care for a family member, a spouse, a child, a parent. So on the ADA, you can only use that law to protect yourself. With FMLA, you can use this law to take time off to care for other people. FMLA is unpaid leave. You can use sick time, vacation time to hopefully have some sort of pay during this period. But a lot of employers offer short-term disability. There are 5 states that require short-term disability. My state, New York, is one of them. You'll see the 5 states here. And it's up for up to 26 weeks of job leave. And I think with the states, the amount is different. The good news is we have short-term disability. The not so good news is that the state-mandated disability isn't a very high benefit. In New York, it's a max of $170 a week, so it's not really a livable wage, but at least it's something coming in for 26 weeks. But also check to see if your employer offers short-term disability insurance. A lot of people will call me and say that they're on short-term disability, which is 26 weeks, but that their FMLA protection ends after 12 weeks, and there's this misconception that people are protected while they're on short-term disability. Not true. If your employer's policy is to strictly follow FMLA, After 12 weeks, if you're not able to return to your job, you can be terminated. The company has to follow their policy, so if they extend medical leave for some, they need to extend it for everybody. But being on short-term disability does not offer job protection. It only offers income replacement. A lot of people call me about Social Security disability and will I qualify for SSD, and I have to say that probably more than 50% of people that apply for disability are not approved. Disability is based on an applicant's inability to work, and they have to establish that as a result of their diagnosis, they'll be unable to work for at least 12 months. They don't have to wait 12 months to get approved for the benefit, but they have to have enough medical evidence to establish that they'll be out of work for 12 months. This is where a lot of applicants have a problem. SSD has a 26-week waiting period. It's based on your work history and how much you've paid into the system. For people that don't have sufficient work credits, SSI is a benefit, but the maximum that SSI will pay is about $800. SSD right now is about $2,200, but again, it depends on the work history and how much you've paid in your Social Security taxes. Very easy to apply. You can apply on the computer, usually the best way to apply. They have listings. Basically, they'll say, well, if this is your illness, this is what you have to show in order to get benefits. And I included the listing for transplants, for bone marrow stem cell transplants. Generally, somebody who's undergoing a transplant will be approved, and then the benefit will continue for at least 12 months from the date of transplantation. Social Security in cases like this will usually do a review every 2 to 3 years. So usually 12 months after the transplant date, you're not going to get a letter saying, okay, you're done, you're off, your benefits are ending. Usually it'll be, they'll take about 2 years or so, and you'll get a letter saying, we want to talk to your doctors, we want to get updated medical information. Another option is long-term disability, which is a benefit that is not required but can be offered by your employer. Again, long-term disability usually has a 26-week wait period. If you pay the premium for your LTD, it's a tax-free benefit. If your employer pays the premium, it's taxable. So if you're given the option, sometimes it's worth, the premiums are usually pretty low. And if you ever have to use that long-term disability, then it's a tax-free benefit. So definitely worth thinking about contributing to the cost of your disability. But the approval process is tough. So start early. I usually tell people don't wait till week 25 to apply. Apply around your second or third month in. Look at their policy, see what their requirements are. See what the definition of disability is. Most of these policies define disability as being unable to do your particular job, at least for the first year or two. And then that definition can change. But it's under the laws that govern employee benefits. You have a right to a copy of all of your plans, all of your policies. So it's worthwhile to get copies so that you can review them. One of the things that I wanted to mention is, as I said, I'm an attorney who provides free legal services to people with cancer, and we actually have a network. It's the National Cancer Legal Service Network. So if you're in New York, you have my contact information. Feel free to call me. If you're out of New York, feel free to call me, and I'll try and help you find a referral. But we do have a website. It's nclsn.org, National Cancer Legal Service Network, and you can plug in your zip code and try and find an attorney like myself in your area who can help you navigate all of these complexities, because I know it's a lot, and this is a lot of information for a short presentation, but I'm happy to answer questions or clarify anything.
Do we have any questions? Please raise your hand if you would like to ask Ms. Wolb a question.
Hi. Talking about disability and one of the things that cancer patients deal with is the chemo brain, and whether or not that is affecting my job. Do you find, have you had experience with going on disability because of that, or can you speak to that issue?
So that comes up quite often. I have had clients who have been on disability because they've been in chemo, and when they complete their chemo, even though they're still feeling the after effects, whether it's chemo brain or other impairments that they might have, the disability insurance company says, well, you're done with chemo, you're better, it's time to go back to work. Or people that are working and have sometimes even worked through their chemo, but then find that some of the cognitive impairments from their chemo have really impacted their ability to work. And so I've seen cases that have been very successful in people going on disability. Sometimes we'll try and have them go through neurological testing to confirm that to get some objective results, where a doctor can say, this is impacted or that is impacted. But it can be difficult at times because a lot of these are subjective complaints where you can't do an X-ray or a PET scan or any type of test to establish that somebody has chemo brain. So it really is on a case-by-case basis, depending upon what the job duties are. I have had some cases with clients where I've had doctors who don't really believe that chemo brain exists and refuse to be supportive. Because one of the things with disability, whether it's Social Security disability or long-term disability through your job, when people call me, the first thing I say to them is you have to talk to your doctor. You have to make sure your doctor's going to support you. You have to make sure that your doctor's going to say that you're unable to work because of these various medical reasons. I also tell them to make sure that they look at their medical records with their doctor, because sometimes people will go in to see their doctor and the doctor will say, how are you feeling today? Rather than going through the long list of, this and that, they'll say, well, I'm feeling okay. And the doctor will write, patient reports feeling okay, feeling good. You have to have medical records that are going to support the disability as well. But certainly with the cognitive impairments from chemo, I talk to clients who have fatigue that lasts quite a long time after their chemo has ended. There certainly has been some success in having them apply for long-term disability. Short-term disability is, I find, a much easier benefit to access. I have very few cases where clients are denied short-term disability, but the long-term disability companies really do a very thorough review. But the key is to get your doctor on board, make sure that your medical records will support that you've had these complaints, and even to have some sort of cognitive or neurological testing to support the impairments. And then people have had pretty good success in obtaining their disability benefits.
Hi. I have two questions somewhat unrelated. One is related to the pre-employment inquiry slide you were talking about, and I understand your feedback on that, but specific to somebody who may be interviewing, and so the employer doesn't ask any of the inappropriate questions, but there's a significant gap in their resume. I don't know if you have any legal advice as to sort of what one says, how much to say, not to say, and then do you want my second question?
Sure.
Or you want to, okay. So my second question is related to unemployment insurance benefit as relates to short-term disability, and this is specific to New York, so maybe you can answer this. With a specific example in a client that I worked with who had used was laid off, went on unemployment through New York, and had used maybe about 4 months, and in that process coincidentally got diagnosed. Then in the transplant phase ended up going on New York State short-term disability, exhausted the 26 weeks there, went to return to unemployment because they were then able to sort of get back into the job market. At this point, that clock, the calendar year, if you will, had come to a year, and was therefore denied access to the remainder, what I would call the remainder of the unemployment, 26 weeks of unemployment. And is that correct? Can they do that?
Starting with the second question first, I don't work as much with unemployment. I have an attorney in my office who does only unemployment, so she handles most of the unemployment matters. So I'm not sure. I do know that, when you, in New York, if you're on unemployment and you become disabled, you can switch from unemployment to disability and collect the disability benefits. But I'm not sure about switching back to unemployment and how long unemployment has to continue. If you want to email me, I can find out because I can ask the attorney in our office. And the first question, that comes up a lot. And I always suggest also that perhaps people talk with job counselors who can counsel them through this process. With gaps in resume, a few things. I'll tell people, think of what you did during this period. Think of, are there things that you can talk about? Did you take a class? Is there anything that you can talk about during this period to kind of deflect if the employer asks what you were doing during this period? Gaps in resume are unfortunately more common now because of the economy. So I don't think there is as big a concern with employers as they have been. But it's a tough one, and usually the key is to try and deflect if an employer says, what were you doing during this period, to try and deflect and perhaps get back to the interview and why you're qualified for this position. But it's a tough one, and I will say that there are times when employers do ask inappropriate questions, and also, have to be prepared to deal with these as well in terms of how you're going to respond if an employer says, why are you limping, or what's, and what I usually counsel people is just, to, again, deflect, talk about why you're qualified for this job. And did you want to respond to this particular?
I had some employment counseling as a result of a bone marrow transplant, and I wasn't able to take the 2-month counseling session during the time that I was ill, but they held it open for me until a time that I was able to actually, sit upright and actually take some notes and things like that. So they basically told me that you don't necessarily have to say it was you taking the time off for some medical. You could just say there were some family issues, family medical issues, and I had to, take some time off. So you don't necessarily have to, you're your own family.
Right. Sure. Family issues, personal issues. The only thing I caution is always to be as truthful as possible, worded in a way so that it's not untruthful, but certainly to say family issues would be appropriate. And then be prepared to pull it back to the interview and this job and talking about your qualifications for this job.
I have my own question. So I did a fundraiser for some of my medical expenses through my, through my industry and people who know me, and a lot of people responded. So that page and that information is now, when you Google me, it's there. And I can't get it off. So, so if people are going to look at me online before a job interview, that's coming up. And so in a way, I can say, I had to take, this time off. So far, for some of the interviews that I've had, it's not come up as a question, but I haven't gotten any jobs. My question to you is also, I have long-term disability and will come up for review in December. And the issue is, can you do your previous job? As far as I'm concerned, I can't run a global software marketing organization. anymore, which required 15-hour days, travel around the world, and I just can't. I mean, I'm here for a day and a half and I'm exhausted. So to actually do what I did before, absolutely not. Now they're going to ask me, well, is there anything, what else you can do? What are your sort of any cases that, where people end up after the private disability with those sorts of situations where you're not able to do your previous job, but I might be able to do something, but certainly, I would never get paid at the level I got paid before.
Yeah, so first, commenting on your first comment about the Google, you have to be careful nowadays in terms of what's on Facebook, what's on the web. I mean, I had a client who got a letter that they were taking him off long-term disability because his partner posted pictures about their trip around the world. And they said, well, if you can travel around the world, then you probably can work part-time. So be really careful about what's up there. In terms of what you have, it's not something that you can control, but not all employers, I think, Google, but I think many do. So you just have to be careful about what's up there. And look, I've had clients who, we've talked about it, and they have said to me, if it's asked, I'm going to tell them I was in treatment for cancer, and they have still gotten the job. Because there are a lot of people now that are really touched by cancer in their lives. They have family members, they have friends, and I have to say I don't want to paint a picture that all employers are not good, because there are a lot of employers that have been really supportive, and I have had clients that have gotten jobs even though they've disclosed. So a lot of it depends on the circumstances, the type of job, etc. With respect to long-term disability, I've done a lot of work appealing LTD terminations, similar to what you've talked about. When you have disability through work, usually for the first year or two that you're on disability, the definition of disability is not being able to do your specific job. After that, the company has the right to change the definition of disability, and usually it changes to any reasonable job given your education and your training. So they're not going to say to you, well, you can go flip burgers at McDonald's, but they could say, well, based on your education and training, we feel that there's some jobs that you might be able to do, even if you can't go back to your original job. I guess the few things I can say are make sure that your medical records continue to support your inability to work. When you see your doctor, talk to your doctor and say to your doctor, write that down if they're not writing it down. If you have a complaint about something that's, whether it's the fatigue or cognitive impairments, whatever it may be, make sure that your doctor puts this into your record. Second is you have the right to appeal a termination, and I work with a lot of people who are very successful on these appeals. The long-term disability companies want to pay these benefits for as short a period as possible. They'd very much like to get you off their books so they don't have to pay you, and sometimes you have to challenge them. And you do have the right to appeal. You do have, to submit medical evidence that supports your inability to work. And I think that's the most important thing, is just to make sure it's documented, everything that you've been experiencing over, the past year or since your disability was approved, so that when that review comes up, they're going to ask for your doctor records, and your doctor records are going to be supportive of the disability. But also not to be afraid to challenge them, because a lot of times they'll try and terminate benefits when actually the person really is still disabled under the terms of the policy. Some insurance policies have return to work benefits. It's worth it to see if your policy offers any type of part-time benefit where you can go back to work part-time, and then they'll apportion what they pay you based on your earnings. Sometimes that's an option, sometimes it's not. So.
A follow-up question. The long-term disability policies guarantee a certain benefit based on your salary. Now, if you need to go, you want to go back to work, but you're not going to make anything near what you made before. Is there any requirement of the insurance company to subsidize the income, based on that original commitment? And the second, one other question before I forget, is who do you, if you want to challenge it, how do you challenge it, and who do you challenge it with, the company or another organization or what?
Trying to remember tell me the first question again.
Sorry. Subsidizing the salary, the original salary, based on the...
Okay. So the insurance policy is a contract. I know it's not fun to read these policies, but you have to get a copy and read it. And as I said, some policies will allow return to work benefits, where if you go back to work part-time or go back to work at a different job, they will subsidize you. Other policies say as soon as you go back to work, regardless of what you're earning, whether it's part-time or full-time, you're no longer considered disabled. So you really have to review the policy and see, is this a policy that's going to subsidize me, which some do, or is this a policy that says, if I go back to work, I'm going to lose this benefit? If you go back to work at your original job, usually there's a period of time where if you test the waters and then decide that you're not able to work, you can get back on the policy without going through the entire review again. But usually if you go back to work for another employer, you lose the benefits of the policy. So it's on a case-by-case basis. If you get a denial, they have to tell you your appeal rights, who to appeal to. If this is a policy that you've gotten through your job, it's governed under a law that gives you 180 days to appeal. So it's a pretty generous appeal time limit. Most people don't want to wait that long because they need the income, so they don't want to wait 180 days. Usually the first appeal goes right to the insurance company. Oftentimes they'll offer you 2 appeals, and I say take them, give them as much information as possible. You have to appeal to the insurance company before you go to court. You have to do what's known as exhaust your administrative remedies. If you go into court, you're going to get booted out because you haven't gone to the insurance company first. So usually you have 1 or 2 chances directly with the insurance company to send them as much information as possible and hopefully get them to reverse their termination or their decision.
Just to follow up on that, I find that a lot of that times they won't actually deny you. They'll say, oh, we need more paperwork, we're still reviewing it. So this can drag on for 6 months or a year. So what do you do if they didn't deny you but didn't approve you and you're stuck in limbo?
But you're still getting your benefits during that period.
Usually not. They cut you off and then they say, he's had periods he's been cut off for weeks,
Really?
6 months now for one policy.
Oh, that's
with
interesting.
no decision.
Yeah, that usually doesn't happen that way. Usually when they send out a letter saying we're reviewing this, they have to continue the benefits. They shouldn't be cutting off your benefits is effectively a termination. And I would challenge that with the insurance company. And I would say, you know what, if you're conducting an ongoing review, you have to continue the benefits until you make a determination that this person is no longer eligible for your policy or your plan.
If it's private and not ERISA, what law would that be that they have to continue it? Or it would be in the contract?
So the question was if it's private and not ERISA. ERISA is the law that governs employee benefits. So it's the law that governs policies that you have through work. For private policies, the contract governs and state law governs. So it depends on how your policy is written. If your policy says, if we're reviewing you, we can terminate benefits during the period of review, then it may be that that's appropriate. But I haven't really seen that happen. Usually during a review, they'll continue the benefits until they've made their determination. But if the policy says they can do it, it's a contract, and they're not governed by federal law, so they can pretty much do what they want as long as it conforms with state law.
I just want to add on to that. What these insurance companies do, the initial denial, they will deny, won't give you a reason. And then they'll wait to see if you appeal within the 60-day time limit. And if you don't, you lose the ability to appeal. Okay? And after you appeal the first time, they can deny you the second time. And after the second time, then your claim gets to be a lot harder to get your claim in. So what they do, they play games, okay? And part of the reason is the insurance companies are unregulated, okay? So you really have to be on top, right on your toes, and being debilitated, okay? Well, most of the people in the room are here because they have cancer. You need a private secretary to be on top of everything. You need someone to, make phone calls. You need someone, and in between, you're trying to get treatments.
Yep.
Okay, so that's a big problem.
Yeah.
But that's what I wanted to add on. But my main question is this: you're going to the cancer place, wherever it may be, okay? And your cancer doctor is writing all the information down. And then you're submitting forms to the insurance company. You give your cancer doctor the forms for disability and everything. Lo and behold, he says, that has to be filled out by your primary care doctor. Well, now your primary care doctor, he's in the dark. He doesn't even know what your particular cancer is. So now you're relying on the primary care doctor to fill out a form that he's totally unqualified for, okay? And if he writes the wrong thing, the insurance company's looking at it. He's got one set of paperwork from the cancer doctor, another set of paperwork from your primary care doctor. And if they don't match up and made up correctly, the insurance says denied. My question is, can the cancer doctor supersede the primary care doctor, or is it in fact true what they're saying, the primary care doctor has to fill out the forms?
I think if you're on disability because of a cancer-related diagnosis, it definitely should be your oncologist or your cancer doctor that fills out that form. If they want something from the primary, so one of the things with the insurance companies is they can say, we want something from your primary care doctor. That's fine, but that doesn't mean you can't send them something from your oncologist as well. And the key with the insurance companies is the more you give them that supports your diagnosis, the better. So if they say, we want something from your primary care doctor, fine, but just make sure that you get something from your oncologist as well. I wasn't going to say this, but I will. I mean, as an attorney who works with people with cancer, I have to say I do not like insurance companies. Whether it's health insurance companies or long-term disability companies, just have these issues all the time. They really want to get people off the books. One of the things that I wanted to mention is that under ERISA, the law that governs employee benefits, you have a right to a full copy of your file. If you get a denial by your LTD company, you can write them and say, I want a copy of everything that you used in this denial. I want to see what doctors reviewed my file. You want to make sure that, I've had cases where I've had clients with cancer and they've had a cardiologist review the file. In one case, it was a pediatric cardiologist. You want to make sure that they have a specialist review the file that's, knows your diagnosis. And with private policies, if it's not governed by ERISA, when you ask, you usually get a copy of your claim file, even though the law doesn't require it. The few times that I've had to ask for one, usually so as a first step, ask for a copy of the file, see what's in there, see what they've used to come to their decision that you're no longer disabled. But my motto is give them everything. Doesn't matter what they ask for. Get as much information as you can. And even, if you have to go to court on this, the court acts somewhat like an appellate court in that they review the records and make a determination. So you want to make sure that the record is as complete as possible and everything is in there that's going to support your disability. But it's a tough one because the other thing they do is sometimes they'll send a form to your doctor every 2 months. I mean, their goal is just to drive the doctors crazy. So the doctor says, I don't want to do this anymore. And they'll say, oh, your doctor didn't complete the form. We're taking you off disability. It's a little daunting.
One more thing I want to say. I had an instance where I had high blood pressure. The doctor prescribed Bistolic, blood pressure medication. The first 2 prescriptions were filled, no problem. The 3rd prescription was denied by the insurance company. And the pharmacist said, you're going to have to give your insurance company a phone call, which I did. The insurance company said, we denied it because the medication was too expensive. And my response was, you're an insurance company, you're not a doctor. You are totally out of bounds and out of your jurisdiction when you're trying to supersede the doctor's prescription to me. They ended up winning, okay? I ended up getting another medication. But I went through 5 prescriptions before I got the right one. Again, the insurance companies are doing pretty much whatever they want to do.
Although I will say, and I'm going to actually be making another presentation on health insurance and the Affordable Care Act. With the new law, there are far more protections in place for the consumer. And, I don't want to go into detail now, but including, better appeal rights under the law, rights to have somebody outside of your insurance company decide whether or not the insurance company has made the correct decision. But, it still happens quite often, though. Insurance companies have the right to say, we want you to go to the generic brand, we want you to go to something that's less expensive. I mean, it's all a question of medical necessity. I did recently have a case with somebody, I work a lot with Pfizer, and one of the things we talked about recently is the fact that generic brands are not the exact same as the name brands. There's little alterations. And I recently met somebody who had severe side effects to the generic brand but could take the more expensive name brand and really had to fight the insurance company despite the documentation that there was something in this generic brand that was causing an adverse reaction, and eventually got them to approve the benefit. But it can be a battle. Even with the Affordable Care Act, we have a long way to go with health insurance in this country.
Thank you, Ms. Wolf. We have run out of time for today's session, but clearly what you presented is so pertinent and important for everyone here. So thank you very much. And
And if anybody has any follow-up questions, you have my contact information. I'm always happy to talk or email or whatever, so feel free.